If you're listening to this video, either you or someone that you know and love have been accused of a felony or are facing potential felony charges in a criminal court. A lot of times felony procedure can be very mysterious, and it can be the unknown, and it's this fear of the unknown that people have to face when going to court. The intent of this video is to give people a very basic understanding of felony procedure in California. There are normally two phases of a felony case. There's a complaint phase and an information phase, and we'll get into what exactly that means. How a felony starts is before a case gets to court, a police officer who's done an investigation or talked to witnesses delivers their case to the DA's office. That can include police reports, that can include videos, that could include audio interviews of witnesses to a case. The DA, who are attorneys, they look over the case from an attorney's point of view, and they decide whether or not a case should go to court, whether or not a case should be a felony, whether or not a case should be a misdemeanor. It's pretty rare for a case not to show up to court. These days, we have big budgets in law enforcement, and we have big budgets in the DA's office. So they will more often than not tend to pursue cases. I get questions, comments from clients and clients' family members, such as, oh, the DA's office probably wouldn't waste public taxpayer money in a case like this. And you'd be surprised at what ends up going to court. And like I said, usually when in doubt, the DA's office, in my experience, will tend to bring something to court. If the DA's office does decide to make a criminal case based upon the police officer's investigation, they file what's called a complaint in court. It triggers a case. It starts a case within the court system. So what does it mean when the DA's office files a complaint in court? Well, a complaint is the name of a document, and it'll say felony complaint on it, and it is a list of the charges. In America, we have due process rights, and you have a right to know what the government is charging you with in court. And the complaint is that document. It's the document that gives you notice, or it gives you reasonable information to know what you will be fighting in court. Before you is an example generic felony complaint. It has, as you can see in the upper right-hand corner, the word felony complaint, and then it has a list of charges. Here I just have charge 1, charge 2, charge 3. There might be one charge, there might be 100 charges. It really depends on the DA's case. Once a complaint is filed, the felony case begins. The first phase begins with an arraignment. Think of an arraignment as the start or a kickoff of the case. A lot of times people are really nervous about the very first court date, and it's actually very anticlimactic. You go to court, you get the complaint from the judge, and you waive formal arraignment, which means you don't ask the judge to read everything that's on the piece of paper. You just acknowledge that you received the piece of paper, and you enter a plea of not guilty to the charge, and you at that point make a decision to go with a speedy trial or not go with a speedy trial. So at arraignment, even though most people are very nervous about it, the only two choices that you really have to decide on that day are, number one, you plead not guilty, and number two, you choose speedy trial or not a speedy trial, which is called a time-waived trial. Now, the ending of the first phase, the complaint phase of a felony case, is the preliminary hearing. So phase 1 starts with an arraignment and it ends with a preliminary hearing. At a preliminary hearing, the DA has a burden of showing the judge that there's reasonable suspicion for each one of the crimes that somebody is accused of. So if they put on a tiny bit of evidence that makes a judge suspicious that the crimes occurred, that's all they need to do. If a jury trial is like a movie, a preliminary hearing is like a movie preview. A jury trial can last for days if it's a misdemeanor, some short felonies, weeks, months, even years in some really big cases. A preliminary hearing is a much shorter version of what's going to be presented or what would be presented at a jury trial. Think of a preliminary hearing like a thumbnail sketch of a jury trial. So if a jury trial is going to last for weeks, a preliminary hearing might last for days or just a few hours. A preliminary hearing is the unofficial midpoint of the case. Even though a preliminary hearing might happen within days of an arrest, or it might happen years later. So you can have a situation where you do a speedy trial to prelim, and the prelim happens within days of an arrest, and then it might take years to get to a jury trial. Even in that situation, the preliminary hearing is the midpoint of the case. We might have to delay a case for a year or years to get everything that we need to present a case at a preliminary hearing, and then jury trial might happen a month or two after that. If the DA can raise reasonable suspicion at a preliminary hearing, then we conclude phase 1 of a felony case, and we move on to phase 2 of a felony case. So the second phase of a felony case is called the information phase. And that's because the legal paperwork that the second phase of the case is based upon is called an information. So looking at the slide in front of you, again, it's just a sample of an information. It has charge 1, charge 2, charge 3, all the charges that the DA will have. And if you look in the upper right-hand corner, there's the word information. So just like the complaint phase, in the information phase, it's the same document, except the word complaint has been replaced with the word information. Phase 2, just like phase 1, starts at an arraignment. And just like in phase 1, you plead not guilty and you choose speedy trial or time waived. The difference is, at the end of the second phase of a felony case, instead of there being a preliminary hearing, there's a jury trial. So you have a start at arraignment, a stop at a preliminary hearing, a start at an arraignment, and a stop at a jury trial. A felony case only stops if one of the following occurs. The DA or a judge dismisses the case. There's a plea agreement, otherwise known as a plea bargain, or you go to jury trial. At a jury trial, you either win, you get not guilty, or the jury votes guilty, or the jury doesn't come up with a unanimous verdict, and that's called a hung jury. And in that instance, the DA can either elect to go to trial again, or they can elect to dismiss. So in a situation where there's a jury trial, if it's 11-1 for not guilty, then the DA is more likely to dismiss. On the other hand, if it's 11-1 for guilty versus not guilty, the DA is probably going to elect to have another jury trial. And it really depends on the personality and the makeup of the DA and the jury outcome. If it's 6-6, that might be a coin flip. I would argue that if 50% of the people wanted to acquit somebody, that certainly is reasonable doubt. But it's really up to the DA and that DA's personality and maybe the DA supervisor. And a lot of times cases that should be dismissed, DAs, just based upon their personality or their personal campaign, will want to keep pursuing the case. There is another alternative to the preliminary hearing phase, and that is when there's a grand jury. Think of the grand jury indicting somebody as replacing the preliminary hearing. So you still kind of have two phases of a felony case, but in the situation where there's a grand jury or a grand jury indictment, that takes the place of a preliminary hearing. So there's still two phases. But the first phase would be the grand jury indicting someone, where there's a DA talking to the grand jury and presenting evidence and absolutely no defense. And then if the grand jury chooses to indict, then the defendant is arraigned on an information. So the complaint phase is skipped in instances where there's a grand jury. And after that, it's essentially the same. The second phase whether there's a preliminary hearing or a grand jury indictment, the second phase is always the same. There's an arraignment on the information, and at the end of that track is a jury trial. It's really important when shopping for an attorney to understand that some attorneys will only charge for the first phase of a felony case. So though they won't make it clear, or they won't fully educate somebody saying, okay, this other attorney, charged this much money, I'll charge less money, but they're only charging up to the preliminary hearing. And then if you don't have money to hire them for the jury trial, then you're back with the public defender after having spent money with a private attorney. And you lose your attorney and everything that you've worked up, your relationship, your defense. If you can't hire them for the second phase, you've lost all of that. And in that situation where you can't afford a private attorney for the second phase, you're left with the public defender. I've never thought that was fair, personally. That's why at Tully & Weiss, we want to represent our clients for the whole case. We want to represent someone from start to finish. So from arraignment all the way through jury trial. If the case gets dismissed along the way, great. If the case takes 6 months, great. If the case goes all the way up to jury trial, if the case takes 2 years, we don't raise our rates. We have one flat rate fee, and we want to stick with you for the whole case. While it is common practice in the criminal defense field to charge for a jury trial, again, we have a flat rate fee that goes all the way up to a jury trial, and our jury trial fees are very reasonable. When talking to an attorney and trying to evaluate, you should ask them, how often do you go to trial? When you go to trial, how often do you win? Not all attorneys are created equal, just like not all doctors are created equal. You want to be careful of someone who doesn't go to trial, who just settles every single case. DA's offices are going to be more afraid of somebody that goes to trial versus somebody that's known for pleading their case out. When you go to trial, that's having leverage in a case. The DA might go to trial and win. They might go to trial and lose. You never know what's going to happen at trial on both sides, so it's something that you need to think about very seriously. However, you do gain advantages of working with an attorney that does go to trial and that is known to go to trial, especially if that attorney has very good trial results like we do at Tully & Weiss. Thank you very much for your time and listening, and I hope this informational video has been helpful to you. Again, this is a thumbnail sketch of our felony procedure in California. For further details and more in-depth discussion, I would suggest that you contact an attorney who specializes in criminal law and specializes in felonies. Thank you again, and I hope this helps.